Good morning, everyone. I'm Disha Wadekar. Um, Amongst many things, I'm a lawyer, and today I think I'll be talking a bit about the legal principles and how they have evolved in the social media age. But most importantly, before I begin, the reason why I'm here, why I was invited even, is because I think I'm a voice on social media as well. And I have tried to effectively use that voice as a lawyer, as an organizer, and as a person from an extremely marginalized, but I would also say completely erased community called the denotified community. I don't know how many of y'all have even heard of it. Has anyone heard of the denotified community here? So these were basically communities that were criminalized at birth by colonial era laws. And these communities continue to face criminal stigma, state persecution, police atrocities, you name it, and it's there. Um, I call it an extremely invisibilized community, not just in social media, but also in the larger public discourse. There's no talk about the community that I come from. And my introduction to social media, or when I joined social media, mostly Twitter, was to really voice the issues and the problems of the community that I came from. And it happened mostly during the COVID period. I think a lot of us became really vocal because we didn't have anything better to do. But I realized that social media was really instrumental in grounding me and grounding my identity, but also grounding me as a lawyer, grounding me as an organizer. I run an organization called Community for Eradication of Discrimination in Education and Employment. It's called SEED. Being a lawyer, coming from a marginalized community, as a woman lawyer, I've faced all kinds of structural barriers in the legal profession. And I realized that we need to do something about it. The organization is basically there to address lack of representation in the legal profession, and we provide opportunities to students from marginalized communities to really rise or do well in the legal profession. But why am I telling you all of this is because SEED, which has now arranged approximately 300, 350 paid internships for students from marginalized communities. And I say caste marginalized communities, I say nomadic communities, I say denotified community, I say Muslim community, I say people coming from the Northeastern region, I say persons with disabilities. All of these students, law students, have been given opportunity through SEED. And honestly, SEED would not have been possible without social media, without Twitter, without Instagram. It is a completely social media led, social media driven organization. A lot of our funding, we don't have any sort of major funding coming from one source. So it is a crowdsourced organization. Um, why am I talking about this is because I do think that social media has been very instrumental for many of us, especially for those who come from marginalized communities who felt that they were not heard before. So it has definitely given a voice to many of us. But I'm also a social media realist in a sense that I don't think that it is the panacea for all ills. Neither do I think that it is the root cause of all evils. I think both of these are like really extreme views on social media, like any other advancement in information and technology. Social media is another advancement in information and technology. And we are all grappling with it while we are also learning from it. We're also learning with it. And we're also growing with social media. And this also applies to the legal field, I'd say, because law always plays catch up with technology or information advancements, right? Law has never really been able to do to walk ahead of these sort of information and tech advancements. And there are many reasons to it. I don't think that law will ever like be at the same pace as these advancements happen. We are also seeing a lot of advancements around AI, you know, generative AIs, and the law is trying to grapple with it. But as far as free speech is concerned and free speech on social media is concerned, I'd say that some of the concerns, like Hussein pointed out, about hate speech are not new at all. They're not coming up because, oh, we have social media now and, you know, social media presence now. They've been the concerns for decades, much before social media, right? There are concerns about misinformation. Misinformation is not a new concern. Misinformation has been as long as free speech and expression has been around. There are concerns around government regulation of speech, right? And I'll talk about government regulation of speech, but those concerns are again not new. So to start with, basically, because we are talking about social media in India, one of the most prominent provisions that we all have to talk about is the right to freedom of speech and expression, which is a constitutional provision, which is in part 3 of the Indian Constitution, Article 19(1)(a), which says that all citizens have the right to free speech and expression. But unlike in the US, where you have the First Amendment, which is almost an absolute sort of free speech right, which also protects hate speech, by the way. In India, this right to free speech and expression is quite restricted. But these restrictions are reasonable restrictions. There are exceptions to these. And I'll read out what these exceptions are because I want to talk a little more about these exceptions. You see that the state can definitely make laws in the interest of sovereignty and integrity of India. So this is one of the exceptions to the right to free speech that is available to individuals. The other is security of state. The other is friendly relations with foreign states, public order, decency, morality, contempt of court, defamation, incitement to an offense. Some of you whom probably are studying free speech around here in the US, maybe some of these things like contempt of court and defamation as exceptions might just be really surprising to you. But yes, we still have those provisions very much entrenched within the Constitution, and these are the exceptions to free speech. So what is the legal principle, like the guiding principle of free speech in India? We are not free speech absolutists. We are more like the European regime, the European jurisdiction, which believes that there are certain restrictions that are necessary and there are legitimate restrictions that are necessary on free speech. And like I said, these are the restrictions. Now, as far as social media is concerned, free speech, the courts have laid down legal principles around free speech for a while. But as far as social media is concerned, one of the first cases on social media and free speech and social media was the Shreya Singhal versus Union of India case, which is a 2015 case. I don't know if y'all are aware of this. Some people are nodding. Y'all are aware of it. But I'll just briefly tell you what the facts of this case were. Balasaheb Thackeray, one of the prominent leaders from Mumbai, from Maharashtra, died, and there were a lot of roadblocks. And there were these two women who on Facebook posted something around that, around the propriety of shutting down the city of Mumbai when a political leader dies. And these women were basically arrested for posting something around this. They were legally arrested because they were arrested under Section 66A of the IT Act, Information Technology Act, right? So India has an Information Technology Act. It's a very ancient, archaic sort of law. They've not really done much to improve it, but whatever it is, the punitive measures were very much there. Section 66A empowered you to basically arrest anyone for information or messages that they pass on through their computer sources. This is the archaic language that they're still using. But yeah, anything that was even remotely offensive or objectionable and the police found that it was objectionable, they could basically arrest this person. Now, these two women there was a huge hue and cry in India around around their arrests, and they were finally released, but they still decided to go to the court, and they challenged Section 66A of the IT Act, and they said that this violates freedom of speech and expression under Article 19 that we just discussed. Now, what was their contention? Because, of course, Article 19, as we saw, has so many restrictions, right? So definitely this probably falls within one of the restrictions, and therefore the state has enacted this law, right? But clearly this Section 66A was extremely broad. This is, in the legal terminology, we call it overbreadth or overbroad sort of regimes or provisions. And it included everything, and I'll tell you what it included. It said that the police could arrest people for offensive comments that intended protection against annoyance. So you annoy somebody and you can be arrested. Inconvenience, danger, obstruction, insult, injury. I think everything that honestly Hussein was referring to would probably fall under that. But yeah, insult, injury, criminal intimidation, or ill will. Okay. And this was the Section 66A of the IT Act. And of course, the court read the provision, and the court was also like really surprised. And the court said that this basically means everything. And the court said that this falls outside the purview of Article 19.2. 19.2 has clearly talked about sovereignty and foreign relations and public order, but this is so broad and this is so vague. And the court strikes down Section 66A for overbreadth and for vagueness. And the court uses something really interesting, which in the Indian jurisdiction we hear for the first time. The court says that provisions like these lead to chilling effect, right? Some of you must have heard of these terms. Chilling effect is when you don't have to do much. You need to just have a law, and the law expresses itself like Section 66A did. And the law basically shuts you down. The law silences you because you have the fear of being arrested, right? So the court calls it the chilling effect. Now, we broadly see that this is the free speech regime that the court is slowly trying to create. We are moving as slowly cases come to the court. Social media is new to the court. Social media jurisprudence around free speech jurisprudence around social media is new to the court. And you see that how the Shreya Singhal case still remains a really landmark case, and the case highlights the need for laws to adapt to technological advancement and to uphold constitutional principles. So as technology advances, we see that we still face constitutional challenges because there are so many challenges that technology poses. But what I'd really like to, and which I really find interesting as a lawyer, is that Article 19, or rather any of the freedoms or provisions of freedoms in the Constitution, are what we call as the vertical provisions or vertical rights. Does anyone know what vertical rights are over here? Okay, so let me explain what that is. Right to freedom of speech, whether it's on social media or whether it's in a public park or whether it's on a sidewalk, these rights are available and these claims are available against the state, right? So state, therefore vertical, right? So if I'm an individual and I have, and the Constitution basically provides me with this right to free speech and expression, I have this claim against the state. So any kind of state regulation or infringement of my right, I can go to the court and I can basically sue the government, right? And I can seek a remedy. So that is a vertical remedy, a vertical right. But what social media has done is we are not just talking about state regulations, but we are also talking about private entities here, which is the big tech companies, Metas, your Facebook, your Twitter, all of these are private entities, right? But right to freedom of speech and expression under Article 19 only talks about vertical rights. So if tomorrow Twitter sort of blocks my account for no reason whatsoever, how do I claim my right? Because this is a private entity, this is not a state. So discussions around this, probably you would have seen in the Sanjay Hegde case, where Mr. Sanjay Hegde, one prominent lawyer in India, had almost a lakh of followers, and suddenly, I mean, not suddenly, he posted something, which was basically a picture that sort of um, symbolizes dissent in the Nazi regime. And I'm sure some of you must have seen that picture where this person is not doing the Nazi salute and everyone else is. And he posts that picture, and Twitter suspends his account without any rhyme or reason, without any notice, nothing. And then Mr. Sanjay Hegde takes this to the court. He's a lawyer, of course. And he is saying, and he's arguing in court. And this case is actually pending, but now in fractures because his account is restored now. Um, he says that, look, social media, even though it is owned by private entities, and the right to free speech is available only against state and not private entities, but it performs a public function. And therefore, they are performing the function of the state in a way. They are like a proxy, right? So he is trying to make an argument of horizontal rights. He is trying to say that, look, we also need to extend right to free speech and expression, especially in the age of social media, to private entities. And they also need to be held accountable for violation of free speech and expression. And one very important development, and a case that I would point out in this regard, is the Kaushal Kishore case, Kaushal Kishore versus Union of India. It's a very recent case, a 2023 case, where the court has basically expounded on this. And the court has said that the right under Article 19 is not just a vertical right that's available like against the state, but can also be enforced against persons that are other than state, that are non-state actors, that are private entities, that are private individuals also, right? And this is an interesting development. Some people have been critiquing this, and we will see more debates as we go and as we see more cases. But this is an interesting development in India. And in fact, I've not seen something like this. I work at the Knight First Amendment Institute, which does a lot of First Amendment work. They file amicus briefs and First Amendment cases in the US. But I've not seen something as interesting as this, because US is still grappling with the limitations of the state action doctrine, the vertical rights, and they have not really expanded in the horizontal rights sphere. So this sort of really seems like an interesting avenue to explore. So basically, when we're talking about social media, what are the three actors? Like I mentioned, like we discussed when we discussed vertical and horizontal rights, we saw that, of course, there is the government, and the government trying to regulate social media. You have the intermediaries, or these big tech companies, who are the social media platforms. They are private entities. And of course, you have the users, right? And each of them is trying to regulate and trying to violate each other's free speech. I'm not very sure, but a few new rights are also emerging around social media. And these are rights that are associated with freedom of speech and expression. So there is some discussion around right to receive information, right? So when on social media, when accounts are blocked, when posts are blocked, my right to free speech and expression also includes my right to receive information, right? And when these accounts are blocked without no rhyme or reason, without any legitimate concerns, that sort of restricts and that violates my right to receive information. So this right is also connected to right to free speech on social media. There is another right that is very important, which is the right to privacy. And I don't think some of these cases have come to court, but we'll have to wait and we'll have to see how they reflect in courts. The right to privacy cases around social media, a lot of your government schemes now, the benefits that you get from the government are now conditional on you disclosing your social media handles. I don't know if some of you all have encountered this. I definitely have. And what that means for our speech and expression, and what kind of chilling effect can that have on our free speech and expression needs to be explored. There is another right, interesting right, which is associated with right to privacy, but also definitely associated with right to free speech and expression on social media, is the right to be forgotten, or the right to erasure, right? At any point, I want to withdraw and I want to say that everything that I've said on social media, my views, or my information, my content, my data, I have a right to be forgotten. I have a right to erase all of what I have put, all the content that I've put on social media, right? So these are the newer rights that we are talking about around social media. Some of the concerns around social media, and I'll talk a little less about hate speech because you've really addressed that so well, Hussein. But I definitely want to talk about the intermediary guidelines, the 2023 amended IT rules. These are draconian rules. They are horrid. But before that, I'll go back to the IT Act. And there is another notorious section in the IT Act, the Information Technology Act, called Section 169A. Now, what Section 169A is doing is it basically grants central government the power to issue orders and directives to block accounts or to block posts on social media, right? And the government doesn't need to do anything. They don't need to provide reasoning as to why they're blocking your account. They don't, in the orders, they don't need to issue notice to the users whose accounts are being blocked. And more importantly, there is a hostage clause which says that failure of the intermediaries to take down these accounts or these posts would lead to imprisonment for up to 7 years, right? So if as an intermediary, I think that, well, this user didn't do anything to, invite this sort of blocking by blocking of account or suspension of account, they don't have a choice. They just have to comply. Otherwise, they would face this fi- punishment of 7 years, which is now called as the hostage clause, right? Um, you see that this Section 169A has been very instrumental in how content on social media has been moderated for a while. And some of us have been wondering, when our accounts are being blocked or when they're being suspended, what is really happening? Is it the intermediary, the platforms that are doing this? Is it the government that is doing this? Are they in cahoots? But clearly, I was reading this Washington Post article, and this is obviously plagued with a lot of, like, there's a lot of opacity and there's a lot of secrecy around this. But there was something called as, like, informally called as the 69A meetings, right? And these 69A meetings were basically where they were around Section 69A, but where the intermediaries and, of course, representatives of the government came together and negotiated basically what accounts need to be suspended and what accounts need to be shadow banned and what accounts need to be blocked and what posts need to be taken down. So this was happening, right? And this is still happening. But some of them really complied with government pressures to take down accounts like Facebook and others. But Twitter really gave it back for a while. Um, and there's this famous Twitter case in the Karnataka High Court that everyone was looking out for, everyone who is interested in free speech and these kind of the First Amendment rights was really looking forward to this case where Twitter dragged the government to the court because the government tried to pressurize them and Twitter didn't give in. And finally, I think last year, Karnataka High Court basically said that basically dismissed Twitter's case, saying that you have to comply with government orders and you have to block all these accounts because you have to. And secondly, there was a fine of 5 million that was imposed on Twitter. So basically, this created a huge, I would say, suppression, but also a chilling effect on Twitter. Like, even court cases can have a certain chilling effect. And suddenly you see that Twitter is like complying with the government guidelines now. Twitter that really took this like brave-hearted stand before, now after after the Karnataka High Court decision is almost back to square one, and they are now, I think Elon Musk made a statement where he was like, we will have to comply with guidelines of different countries. We can do whatever we want to in the US, but in other countries, we will have to comply. So you see the stoning down that is happening. So, in the meantime, what the government is doing is when this Twitter case is happening, there are these intermediary rules that the government is trying to push in 2023. And I'll just highlight some of the important provisions. One is that when the government issues orders under 69A, uh, social media intermediaries are supposed to take those accounts or those posts down within 36 hours. Otherwise, they face what you saw was the hostage clause, right? They are all supposed to appoint a nodal person who 24/7 coordinates with law enforcement agencies and hands over any data that is asked from them, right? This is where the surveillance aspect comes in, right? There is, of course, the hostage provision, Rule 7, where intermediary, if they fail to observe the rules, they will face punishment. So these are some of the intermediary rules of 2023. One important amendment was that these rules empower the government to create a fact check unit, which may identify any information on social media as fake or false or misleading, right? And in respect of any business of central government, and thus require social media intermediaries to take it down. So all of this is coming under the intermediary rules. You're clearly seeing that there's a huge government crackdown on your free speech on social media. Um, and you're seeing that intermediaries are also bowing down. They're not the most neutral entities. They were never the most neutral entities anyway. But now you clearly see that when they've asked to bend down, they're like literally crawling now. And I think that's probably how it is going to be. In the recent, so these guidelines were challenged by Mr. Kunal Kamra in Bombay High Court. Some of you probably have been following this case. It's a very important case. None of the social media intermediaries, including Twitter, are parties to the case, did not feel the need to challenge the intermediary guidelines. So you know what they're also doing, right? At the moment, I'll just tell you what the at what stage this case is. The Bombay High Court has given a split verdict. And now this is before a third judge, and the third judge will basically decide if these uh, the draconian intermediary guidelines are all right, or they do violate free speech and expression, right? So this is mostly about where we are at. We have the government regulations, we have the intermediary regulations, and we, of course, coming to what you were saying, Hussein, about hate speech and the concerns around hate speech and misinformation are large. But what I'd like to say here is, as lawyers, we are often taught the harm principle because we are also concerned about hate speech on the one hand, but who is going to be that arbiter of the hate speech, right? Is it going to be the government? And then what is going to guide the government to decide what is hate speech, right? And like, given our experience with the government and what kind of an arbiter it has been, um, what we really need to do is we need to be guided by something that we call in the legal fraternity as the Mill principle, which is John Stuart Mill who gave the harm principle. And the harm principle basically, as applied to free speech, says that um, the only justified limitation on free speech is when it poses direct harm to others, right? So if we want to balance free speech with hate speech, how we evaluate what is hate speech, or what is the speech that needs to be restricted, or that needs to be that people need to be held accountable to, that should be guided by the harm principle, whether this speech has caused or is causing or will cause direct harm to other individuals, right? So speech that merely offends or speech that challenges societal norms, according to Mill, should be tolerated but also encouraged in the pursuit of truth and progress, right? And there are some sorts of First Amendment absolutists who say that more speech is better because it actually sort of uh, helps in diluting the harmful speech, right? So the more the speech from the margins, the more it will help in diluting speech. And that is one school of thought, and one might not necessarily agree. The other school of thought, which is those of the critical theorists, they are saying that, well, free speech is creating, like you were talking about, which is a very critical perspective, which is, well, this is only entrenching social media, and these sort of platforms are only entrenching the existing hierarchies for us, right? They are not doing anything new or anything better. Yeah. So just to end, I would end with um, Alexander Micheljohn. Alexander Micheljohn is one of my favorite First Amendment theorists. And he talks about how free speech not just promotes democracy, but is also essential and necessary for a democracy. And he, in fact, talks about, he sort of, when he talks about free speech, he is not talking of free speech as this sort of fountain from where, like rhetoric sort of fountain from where free speech is coming from thin air, but free speech that is really grounded in the idea of self-governance, right? Where we, the people, tell the government what our views are, what we want, what our demands are. So he basically grounds free speech in self-governance and therefore democracy. And so if we, to just end, because I know you've gotten up, but if we, the people, as you know, that's how our constitution, Indian constitution starts, the US constitution also starts. So if we, the people, are not permitted to argue out the issues of the government, if we, the people, are not permitted to argue out the issues of government, how can they be what they must be in a democracy, right? And by they, we mean the rulers. So thank you, and thanks for being patient with this probably boring talk.